meeting room at the county courthouse. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
AM 1240 and 92.7 FM's fast forecast now. For a morning, cloudy and warm, 73 degrees in the Chattanooga area. 77 is our high today. 68 is a low. We are expecting rain to come in a little bit later in the day at about 2 o'clock in the afternoon. Rain should start to pour in and continue until Thursday, even into Friday morning. Rain begins to clear up as we reach our weekend, with highs getting back up into the mid-80s, highs in the upper 70s throughout our week here. That's your fast forecast now.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Good morning, Chattanooga. This is Jim McCoon with Clay Whitaker. Welcome to Legal Bytes. This is our weekly program where we talk about legal issues that can affect your lives, your families, and your business, and try to give you some little insight or as my mom used to say, a dollop of knowledge that you might can use in your everyday lives. And Clay, I've had a real interesting morning with respect to the events that are going on in Chattanooga. I went over to the Chattanooga Hotel and spent time this morning at the public meeting or hearing that's going on with respect to the Judicial Vacancy Commission.
That vacancy is related to the retirement of our now current Circuit Court Judge Neil Thomas.
That's correct. Neil, or Judge Thomas, advised the governor, I think it was back in April, towards the end of April, that he intended to retire effective October 5. And so notices went out, and we've had, I think it's 9, it may be 7, but I think it's 9 separate attorneys here locally have applied to fill those shoes that Judge Thomas has occupied for a number of years. And the way we do it in Tennessee is we have a Judicial Vacancy Commission that will receive all those applications. And then what they'll do is they'll set a public meeting at which time members of the public are allowed to speak for or against any particular candidate. All the candidates, when they submit their applications are online and are available for review. And they ask information with respect to family, education, training, experience, your practice and experiences in your practice. How many jury trials have you had? How many cases we have? What type of clients have you had? So that we can evaluate, whether or not they're the appropriate person for the judgeship.
Well, Jim, is that the part in the ceremony where you get to stand up and object to these two people being joined together forever?
Different ceremony. I think let's don't confuse the marriage with the judicial vacancy. But it was extremely interesting. The hearing or the meeting started out with each of the candidates getting up and doing an introduction, and they could either introduce themselves or they could have one speak to the commission on behalf, or they could divide the time up. Each applicant had 5 minutes. And then
were you impressed with any of the applicants this morning?
Well, I know all of them and have either tried cases with or against most of them. And so, I already have practice knowledge and opinions based upon those experiences, which are not relevant because I'm not on the vacancy commission. But I did sit through, and then what happens is after all of the candidates are introduced and people speak for, it was very interesting. The chairman of the commission opened up the floor to anyone who wanted to speak, particularly against any individual applicant, and no one came to the podium. And then they start an interview process. And the way they do their interviews is the applicant comes up to the podium, and one commissioner has been assigned that applicant to basically be their mentor in this process, get to know a little bit about them, and then interviews them in front of the public, asking very hard questions about their experiences and like. And then the mic basically is passed up and down the table of the commissioners to let any and all ask any additional questions they may have. And so it's a very interesting process. What's the most interesting to me is, as I understand it from what's going on in the other cities where there's been vacancies, is they don't actually deliberate. They stay in open forum, in front of all the public. And after all the interviews are done, they basically pass around a ballot to each person, and they vote for the 3 that they'd like to go. And the purpose of this commission is not to pick the judge. They pick the top 3 or a slate of 3 that are then tendered to the governor, and Governor Haslam then, out of these top 3 that are provided to him, is able to choose the judge.
Sounds like it's a little backwards, though, Jim. I mean, isn't the time that you get to stand up and complain about a judge after they've taken the bench? So it seems like maybe we ought to try them out for a little while and see if we like them. And if they do a good job, then call for people to complain.
Well, well, that just never works. But, talking about the judges and what goes on, we are very lucky in this town. We have currently 6 very good, what I consider major trial judges. That is the 2 chancellors we have in the courts of chancery, and the 4 circuit court judges we have, which are the courts of primary jurisdiction. We do have
for civil cases. We'd throw our other 3 criminal court judges in there too. They
absolutely do a great job, but that's on the criminal side. You're absolutely right. And Chattanooga is different. There, in the smaller regions of the state, your circuit judge hears both civil and criminal, and he'll have a civil docket one day and a criminal docket the next day. But in Chattanooga, because of the size of the community here in Hamilton County, we actually divide the criminal court from the civil judges, who are the circuit judges. And
we've gone through this process recently several other times. We replaced recently had one of the general sessions court judges had to step down for personal issues, and then
health
issues, and then I believe the same thing occurred with regards to a criminal court judge. So the process does work, and it works apparently fairly well.
Right.
We haven't had any violent revolutions because of the changes that have been made. So, and these judges have done very well. That have taken over these spots that the community needs.
I agree. And hopefully the commission today will do a fine job for Hamilton County in choosing the top best 3 candidates or applicants for the judgeship position. I know that there's always an interest in not only their experience. Are they mostly a plaintiff attorney? Will they have been that way? Or are they mostly a defense attorney? Will they have been that way? Or do they have a varied practice where they can look at everything? We have a very heavy domestic docket here in Hamilton County and circuit courts, being a lot of orders of protection, a lot of divorces and modifications and child support cases. Do they have experience in those areas? And
well, if they don't, when they take the bench, they will.
Yeah. And then lastly, because the cases that are the high dollar cases and the most sophisticated cases are the cases that are, dealing with, businesses and commercial issues that don't go to chancery, that sometimes go to circuit. And will they have the experience and the knowledge and the capabilities to deal with those issues? And on top of that, they got to be impartial. They've got to be able to control the courtroom. And there are several very strong-willed attorneys here locally that, a judge will have to be able to control. So there's a lot of things to consider when you're doing this. And then lastly, let's assume you pick the very best candidate and the governor decides to make that person a judge. Are they electable? You can have the very best judge in the world, but they're only going to be judge until the next election. They're not electable in this community.
That's true, Jim.
That's another thing that has to be considered.
Well, we're very fortunate. We've got a very good bar here in Chattanooga that's gets along well, follows the rules, both the rules that allow you to practice law properly and those ethics rules that help you to be a good person and a good attorney. So,
I agree. I think that this community is lucky in that regard. But, as we talk about these things, there have been some issues that have happened in the past few years with the legislature and efforts by the legislature and by lobbying interests to curtail what goes on in our courts.
Well, that's really the topic we want to talk about today. So let's introduce it. We were going to talk a little bit about damage caps, about what we would call the area of the law is called torts. But we were going to talk about that and about remedies. We're here. This is Legal Bytes. This is Jim McCoon and Clay Whitaker. Call us at 800-8949 at 92.7 Talk Radio, Nooga Radio, Chattanooga. Right. And we'd be pleased to answer your questions about any of these issues we're talking about. But the first thing we were going to mention, though, is in regards to damage caps. Many people may not know that with regards to personal injuries, Jim, we've got a damage cap law that started in 2011. Our legislature thought they would do that, implement that law back in 2011. It caps non-economic damages.
Right. And if you really go back to the history of it, I think the U.S. Chamber of Commerce is the driver behind that. And then when our legislature was looking at it, they talked about the inequalities and the injustices that were occurring in our courts. But the real driver was to try to make Tennessee more business friendly, because if businesses and insurance companies will come into the state and do business and feel like they've got some protections with possible liability for damages in the courts of this state, or protections with respect to their exposure, then, Tennessee seems to be more viable as a domicile for those businesses.
Sounds like some fake news was involved in this, Jim.
Well, I'm not going down that Trump road with you, buddy. But
I don't have a Twitter account. I was just going to say. Sounds like somebody did some plowing in a field that wasn't necessarily true. So.
Well, and I do agree with that. I mean, and I always said when you saw these members of our state legislature voting for this, that, if it was a member of their family, if it was their child that was involved in a horrific accident or an incident where they were damaged very badly, they'd be on the other side of the fence claiming foul.
That's right.
But and basically what happens is and people in Tennessee don't seem to realize that this is in place, because I know I've got a case right now where I've got a family with a family member who's been horrifically damaged, extremely bad injuries, and the cap does not apply to what we call economic damages. Anything that you can put a dollar amount on or calculate a dollar amount on. For example, your medical bills are not capped. If it takes $100,000, if it takes $2 million to treat this individual for their injuries, that's not capped. If there's lost wages, those lost wages while you're in the hospital or in rehabilitation are not capped. It's whatever is lost is lost. The future ability to earn income is not capped. So that if you can calculate and show where, because of these injuries, maybe you've lost a leg and you're no longer able to do what you used to do in the plant, and you're going to have to go through vocational rehabilitation and learn some other job, and you won't be able to earn as much. That lost potential for earnings is not capped, because it's a future, basically future on lost wages.
And that will occur also with regards to historically lost wages. So if you were out of work, you couldn't work for a while.
So lost wages past and future are not capped by what the legislature did. What basically the legislature capped was what we call the soft damages, or the ones that are non-economic, and that would be your pain and suffering, your loss of enjoyment of life, your consortium, which consortium is the loss of love, affection, and services of a loved one and their family. Say your spouse, is injured terribly, and your spouse can no longer do things, that they normally would be involved in doing in your relationship. That's all within the cap. And all those things now, the standard cap is $750,000. And what they also don't understand here in the community, at least from the clients that I've talked to, is that it is an aggregate number. So let's say that you've got a child that's been injured and terribly, and that you as mom and dad, have both suffered dramatically because of what's happened to your child. That pain and suffering of your child, as well as any damages that mom and dad have incurred in aggregate, can't exceed $750,000.
Well, Jim, this strikes. When we were looking up, doing some preparation for this show, it really strikes at the essence of what I would simply call the European sort of model of jurisprudence. It goes all the way back to the Magna Carta, where a man has the right to ask the jury of his peers to compensate him. So back in the day, when if it was 1,500 years ago and you ended up in a set of circumstances where you wanted some compensation, you could go and ask your chancellor that was in your English court, or if it was your French court, and you could have a trial, and you were able to get compensation based upon whatever damages you were able to prove.
You could do that 10 years ago in Tennessee.
And it's been that, and it's been that way up until 10 years ago, until our legislature has decided that if you were, let's say, horribly injured, burned terribly, that amount of pain that you suffered cannot be taken into compensation if it exceeds $750,000. And the other part of it is, and if it was an amputation, it's up to $1 million. Or there's a couple of
there's
spinal cord and that. But
if the burns exceed or third degree and exceed a certain percentage of the body, or the injury was caused in the part of a crime, and so the felon caused the injury.
And so the other part of it is that the lawyers are not able to tell the jury that is finding the facts of a case that there's a limit. So you can present all the evidence you want, and you can tell them to present that you want to present evidence about pain and suffering, and you want compensation for that, but you're not able to recover for it after the jury awards, say, a dollar amount that includes that damage award that exceeds the $750,000 in pain and suffering.
That's true.
That's not fair.
Well, I mean, basically what would happen is you try your case, and if the jury came back and determined that you had lost wages of, say, $50,000, you had medicals that you should be reimbursed for $300,000, and then you had pain, suffering, disfigurement, loss of enjoyment of life and life, and they were going to award you $3 million. That would be the verdict, but that would not be the judgment. Because what would happen then is there would be basically, as you put it, it's a remediator, which we're used to judges being able to do when they hear the proof sometimes and the law, but it would be a remediator that's been set forth by the legislature that says that $3 million in non-economic damages is now going to be adjusted back down to $750,000.
Well, we're here at Legal Bytes. We're talking about the issue of tort reform damage caps that currently exist in Tennessee. It's 800-8949 if you want to give us a call. We're at the law firm of McComb, Williams, Ashley, and Stanley. We handle these kinds of cases, and we'd be pleased to talk about those issues with you at our office, 756-6400. So, Jim, it seems to me, we're here kind of winding down this half hour. We'll talk some more about the second part, but one of the issues that we've kind of brought to mind is how can this be fair with regards to equal protection? So, you'd mentioned that the driving force was Chamber of Commerce. They're looking out after the interest of business. And so in terms of our arguments related to equal protection, you've got the individual who now is not being equally protected under the law by the way that this damage cap applies, as opposed to the business interest.
Right. And you've also got an issue with respect to whether or not the legislature, by passing this, has invaded the province of the jury and each citizen's right to jury trial.
Well, and those are things we want to talk about, certainly a little bit more detail. Our Constitution, many Tennesseans know we have one and don't know what it says. I think one of the flaws of our educational process, I do recall many years ago when I was in the elementary school, we did brush across it, but it was so disjointed, I couldn't tell what we were talking about. As a young child, as I've grown up and been involved in the law, we certainly pay a lot more attention to our Tennessee Constitution and how wonderful a document it is, prepared well by the men who actually engaged in that debate and protected us in regards to the issues that are set forth in the article. So one of the things that it does very clearly is it sets the rights out. You have a right to a jury trial, and that your property can't be taken. That includes your liberty, your life, and your body without compensation. And it says that the circumstances with regards to how the legislator acts can invade the province of the judiciary.
Now, Tennessee's not the only state where this is going on.
It's not. It's nationwide. There, and you'd indicated the driving force being the business interest represented by the Chamber of Commerce. Every state's faced it, and many states have ruled and held that it is unconstitutional to cap the damages for the very reasons we've talked about. And particularly if you consider, the idea is always that somehow juries run wild and award damages that are unreasonable. And I think the one that gets brought up, the hot coffee case gets brought up all the time. Well, just in terms of that set of circumstances, in our state, many states that surround us, we had what we've already mentioned, which is the rule on remittiture.
Sure. Hold on one second.
Sure.
I think we got a call coming in. Hello, this is Legal Bytes. Caller, you have a question or a point?
Yeah, good discussion, guys. I found in arguing cases pro se for many years in court that there is no law per se, as there used to be 100 years ago. Judges do whatever they want to do, and they almost always ignore the law if they don't like it. I mean, look at the Gaddies. She's in jail for contempt for not allowing a violation of the Fourth Amendment search of her house. And a right can't be turned into a crime, but I've seen it over and over again covering trials. Thank God there's guys like you that mention rights and believe in rights and go up against these 800-pound gorillas. So thank you.
Thank you, caller, for your call.
Well, caller's right. Jim, this is one of the things we're facing now. And you can tell this in our political discussion. Many of the groups want to limit the rights of other groups to talk about issues. We want to make sure that the conversation is full and complete, including the right for people who are injured to be able to discuss and present evidence before the jury about how badly they were injured.
Right. And just to clarify, as I understand Ms. Gaddy, she's right now incarcerated on a contempt. She's not incarcerated for trying to enforce her Fourth Amendment rights. There was a ruling by the court with respect to an ordinance, and it may or may not be applicable, but that's what's going on in that courtroom at the time. And Chancellor Stewart, as I understand, has given a directive that she won't follow, and as a result, her incarceration is as a result of failing to follow an order, which is contemptible, it's contumacious conduct, and is punishable by incarceration or by fine or by both. So understand, this is not where we've got Chancellor Stewart, who's a very good chancellor and a good representative of the judiciary, putting her in jail for exercising constitutional rights.
Well, and I would agree with that. And, we certainly feel for Ms. Gaddy. Apparently that's a very complicated and difficult case. That community over there, over in the Valley, can handle it. We believe that the process of the rule of law should apply both to the big and to the small. So we hope Ms. Gaddy is able to find someone to help her out in this case. And if she's acting in ways that are contumacious, as you said, that's a big word, Jim. But if she did, hopefully she'll hear this radio broadcast and see that she needs to comply with the court order and then take up the discussions about the law before the proper tribunal.
Okay, let's see. I think we've got another call. Legal Bytes, can we help you, caller?
Okay, I'm gonna challenge you on that. Callie was convicted for shooting people in the hole, and in Nazi Germany, you're not required to follow an illegal order, and that was an illegal order of the court. They couldn't compel her to do that. She's standing on her constitutional rights, and we've seen it over and over again. When that black woman was pulled from the bus because she wasn't going to ride back to the bus, she had to go to court, and the court said the law was unconstitutional from its inception. Thank God for people like Carol Gaddy. So, thanks.
Well,
thanks, caller. We appreciate you calling in.
With that, we are at the half hour. Play. It's been an interesting discussion, and I appreciate the calls from the caller. And we'll talk to you again about these issues of remedies and constitutionality of our remedies and gaps in Tennessee when we return.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
3, 2, 1.
Chattanooga Radio, AM 1240 and 92.7 FM's news now.
At the racetrack gas station on Battlefield Parkway in Ringgold, police say that a man burst in, ordered everyone out. He had a gun and then began taking money out of the cash register and barricaded himself inside the building. Bad news for the suspect, however. He was right near a SWAT team training area. They responded to the gas station immediately. After about an hour and a half of a standoff, the suspect came out of the gas station with his hands up and with no gun. The police say he does face a robbery charge. County Mayor Jim Coppinger made an announcement on the county courthouse steps on 10:30 a.m. that taxes would be going up in Chattanooga. The county will be raising property taxes to bring in funding for schools, a new sewage treatment plant, and an expanded workhouse. County Mayor Jim Coppinger says the time is now. A public hearing will be Wednesday, September the 6th at 8:30 a.m. at the County Commission meeting room at the county courthouse. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
AM 1240 and 92.7 FM's fast forecast now. For a morning, cloudy and warm, 73 degrees in the Chattanooga area. 77 is our high today. 68 is a low. We are expecting rain to come in a little bit later in the day at about 2 o'clock in the afternoon. Rain should start to pour in and continue until Thursday, even into Friday morning. Rain begins to clear up as we reach our weekend, with highs getting back up into the mid-80s, highs in the upper 70s throughout our week here. That's your fast forecast now.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
You've been in a wreck.
756-6400.
You've been wrongfully fired.
756-6400.
A turkey is suing you out of the blue.
756-6400.
Confused about a business startup?
756-6400.
That's the number for you. 756-6400. Right here, right now, Chattanooga. Call now. Top flight legal help awaits. Get biz advice now. Representation to fight for your right. What are you waiting for? That's 756-6400. Don't sit on your rights. You've got remedies. Turn your tragedy into cash. You've got the solution, from estate planning all the way to probate. Act now. Top attorneys in Chattanooga are waiting to help you get relief. Act now. No out of pocket. You don't pay a dime until we win, so win with us.
756-6400.
Call now. Top flight legal help awaits. What are you waiting for? That's 756-6400. Turn your tragedy into cash. Act now. No out of pocket. You don't pay a dime until we win, so win with us.
756-6400.
756-6400.
You used to call me on my cell phone.
When you crack your screen, mess up your charge port, you get soaked in a rainstorm, what do? Save money, save big, fix it, get surgery. There's a cell phone hospital near you. It's the Cell Surgeon. Adam Disbro, the man in white, he replaces your screen, fixes your buttons, gives you back Twitter, Facebook, your online universe. Walk-in patients go to Cell Surgeon in Ottawa. Cell Surgeon is new in Ottawa, next to Zaxby's. Other docs in the cell repair business are just lab coats. The doc at Cell Surgeon is the best. He wants you to be happy, fix your phone, save money, and save time. Every minute is valuable, and Cell Surgeon doesn't want to waste a second. Your wireless MD, the Cell Surgeon, quick and precise with your device. Takes an hour or less. Northgate Mall, Cell Surgeon next to Old Chicago Pizza, 900-8263, thecellsurgeon.com. Like him on Facebook.
You used to call me on my. You used to.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree? Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
All right, well, we're back to Legal Bytes. This is Jim McCoon and Clay Whitaker, and in the first half hour, we were discussing the the changes the legislature made a few years ago and how it's playing out in the court system with respect to damage caps and the effect it has on the constitutional rights to trial by jury. And Clay, you were talking about the fact that this is going on in other states as well.
Yeah, sort of the jurisprudence that we got going on here first, Jim, is most of the cases where the issue's been brought up that's challenged the constitutionality of this particular statute, the issue's been held not to be ripe. Basically, what that means is that there's been no damage award where a judgment has been reduced. So the damage award might have been in excess of the cap, but then the judgment, as you mentioned earlier, that term being the judgment, is the actual award of the court, the order of the court that says that the jury's finding is X. So let's say it was in excess of the amount of the verdict found. The court is instructed then to cap those non-economic damages. We haven't had a case that's gotten ripe at that point with all the factors that are necessary to challenge the constitutionality of it. And so we've had a couple cases that have gone up, and they basically said we just have to wait until this becomes an issue.
Right. Judge Thomas here locally had a case that went up a couple years ago where he had determined that the legislative caps on damages were unconstitutional, and the Court of Appeals determined that it was premature, as you just said, and not ripe. And then there's been a recent case, I think this year, where that's occurred.
Yeah, that's the same thing that happened this year. So it's a same posture, nothing's changed.
And frankly, I think that that's correct. I think that there has to be a situation where you try your case to verdict. The jury comes back, let's say, with $3 million in non-economic damages, and then because of the legislative cap, the court comes back and says we're going to remit that $3 million of non-economic damages down to $750. At that point in time, then it's appropriate to take that issue up to the Court of Appeals on challenges with respect to the constitutionality of the cap.
So that's where we're heading. Is we're waiting for a case, and I'm sure it will come out. So the issues that continually are raised and have been dealt with in other states, I can tell you that in Georgia, there's a case that was held in 2010. The Georgia State Supreme Court held that the issues related to a cap on non-economic damages as enacted in the Tort Reform Act of 2005 violated the Georgia State Constitution's guarantee of a right to trial by jury, and that section states that a right to trial by jury shall remain inviolate. And so what the court held in that case, and these are the kinds of issues that the cases that have come down that have found a violation of the right to trial by jury, essentially hold that the legislator's actions in enacting a cap violate the jury's right and the individual who's proceeding to trial to have the trial by jury to find the facts and to award damages. And so what's happened in that case, and similarly also in Alabama, it follows the same line. In the Alabama case recently, there was a finding that the cap that the Alabama legislature tried to institute violated equal protection and the right to trial by jury. But they held, and this is one of the other strains of this discussion that we need to talk about, they held that caps on punitive damages was okay. And the reason being that punitive damages are not necessarily awarded strictly to the individual, but are more of a societal damage or a damage to punish the tortfeasor for some egregious action. In our state, it requires a standard that is in excess of the ordinary negligence that's required. So it could be wanton, reckless conduct, gross negligence, intentional conduct. And that sort of conduct, the court necessarily says we can punish those people for that conduct that is in excess of ordinary lack of care, but that the damages are limited. And so the trend, it seems to be in the United States at least, is that some of those damages may be awarded or allowed for the person, the individual who brings the claim, but then the state may limit it or they may claim part of it. I think Alaska, I looked up, Alaska actually claims part of those damages, gives half to the individual and half to the state coffers. Like a tax.
Then I want general counsel of the state at my table working, trying to get that verdict.
I know he ought to have to participate. So anyway, that's kind of the trend it looks like for us when we're trying to represent the individual. You're sort of swimming upstream right now, but eventually I think we're going to have a case that comes out. Tennessee's Constitution is very strong. The right to trial by jury is sacrosanct. It's been that way for 1,000 years or more in our jurisprudence history. I don't think that's going to be this is going to be allowed to stand. I think our court's going to find that the individual has the right to make this claim and to pursue the claims, and that's important. It's important for our jurisdiction, for our process. You indicated, we had callers earlier, we're talking about an individual that's battling an entity. It's very difficult for her, apparently, to make her case. We don't know the facts of that case, but that's the same sort of problem we always run into, is the individual has to battle a larger entity, and by doing so, they're at a disadvantage.
Right. And that's, and to basically tie their hands by putting judicial or legislative limits on what they can recover, despite what the jury may find after hearing all the proof, has always been a problem from my standpoint. And listeners, if you've got questions about this or would like to have a comment that you'd like to make with respect to these issues and the caps on remedies in Tennessee and the like, please call us. We're at 423-800-8949. That's here at 92.7 FM, Nooga Radio. We'll be happy to discuss your issues, or if you'd like to discuss these matters privately with Clay or myself, you can call us at 756-6400, and we'll be happy to talk with you off there.
Well, Jim, one of the other things we mentioned in the first half, we didn't get to fill it out very much, is that there was a system already in place prior to the legislature deciding to act. We already had rules that required where the court believed that the verdict by the jury was not supported by the evidence, that the court has the authority upon motion by one of the parties to change that verdict.
Absolutely. Well, first you had the quantum of proof going into the jury, and it couldn't be speculative. It had to be based on actual proof, not hearsay and the like. So you already have evidentiary limits to make sure the jury does not hear anything that's not appropriate or sound with respect to establishing what damages may have been incurred. But on the back end, you're absolutely right. After the verdict is rendered and judgment is put down thereon, we had both a procedure for an additor if the amount was minimal and was not sufficient based upon the evidence, where the plaintiff could come in and ask for the court to award more and increase it based upon the proof. And we also have a remediator procedure, where if the damages, again, the runaway jury that you always hear about, where passion and emotions took place instead of logic based upon and reason based upon the evidence, then you have a way of remitting it. The legislature, and that's part of the argument, the legislature has taken that away from the judiciary by legislating a remediator at $750,000 in most cases for non-economic damages. Well, they basically said that no longer is sufficient.
And that's not right, Jim. One of the other things that strikes me about this is, we have the concept of things being arbitrary or capricious in terms of either rulemaking or law or legislating. And it seems to me that trying to aggregate every case excludes the possibility that you might have people that are so severely injured they need to be compensated above this amount that we're talking about, this cap that's on, and that's really arbitrary. The fact that you would just pick a number out of thin air and say that's what needs to be the limit denies those people who may have suffered a horrific, tragic injury, and the pain may be so terrible and so long lasting in life that you can't have compensation for that. So
especially where you've got multiple plaintiffs arising out of the same incident, but you've got perhaps one injured and the others are family members who have their own separate claims. But non-economic damages are going to be aggregated pursuant to the statute, so that whether it's one or whether it's all of them, your non-economics are capped at the aggregate of $750,000. Again, in most instances, there are exceptions.
Well, it's funny to me, Jim. You hear about the runaway jury that awarded too much money. Did you ever hear of the hard-hearted, skinflint jury that didn't give enough? Nobody ever gives the press for that one, where the poor plaintiff was sitting there and got nothing, though they deserve something.
Yeah, or there's been several cases in Chattanooga area where the damage have been just the medicals. So we're going to award just what's been spent in medicals for this child, and forget the pain, suffering, forget the consortium claims of the loved ones, all the loss of enjoyment value. We're going to, if you had $9,000 in meds, that's all you're going to receive. And no one complains.
You've been practicing law. I've been practicing law over 30 years, trying to look at this set of circumstances. It always strikes me that the community always has the idea that a jury award is in some way unreasonable, that it is a windfall, that there's some conception in popular culture that juries award money to injured persons and they get some sort of windfall out of this without regard to the consideration of the proof. The proof typically shows it's not a windfall, that if the person who was injured had their choices, they'd rather not be sitting in the plaintiff's chair. They'd rather be having the body the same condition it was in before that person acted in a way that was negligent and injured them.
Absolutely. I agree. And I will tell you, having tried cases as you, that those 12 people in the jury room and those 12 people during the course of the trial that are sitting there in the box, or when you put them all together as one unit, are the wisest, most intellectual people you've ever met, because what they do is they have a collective knowledge, both by training, by experience, and when they hear the proof and they collectively render that verdict, that's why our system works. I mean,
I agree with you, Jim. It does. It is an amazing thing, and it's sort of the voice of the community is to speak on a particular issue, and that's an important thing that we should never have taken away from us, which is why it's framed so elegantly in our Constitution at the state and the federal level.
Agreed. And I will tell you one of the really interesting and fun things that I've done is when I've been in trial advocacy seminars, and you'll have a mock jury hear a case, and then they'll have video cameras in to surveil the jury room as they deliberate. Having never seen how a jury actually works, it is amazing to watch them work and how they talk about elements of proof that, we as lawyers may not have thought that was even important. That the jurors will pick up, that a female juror will pick up things that are more important to her than a male juror will pick up, that he may have looked over. And so when they work as a collective unit, it's amazing. And why our legislature will not honor that and understand that they in this community know what, as a collective unit, will know what's appropriate. It's just astounding.
It is. Hey, Jim, I tell you, I understand historically, I believe that the number 12, so the 12 people of the jury actually has a biblical tie to it. So that the idea that the legislature would try to supersede what has been biblically ordained, in the sense that 12 being a perfect number was the correct number to have in terms of a juror, and that juror is able to make proper decisions, that the legislature think that they could come in and put a cap on the damages and exclude that wisdom that you're talking about, I think is really clearly wrong and foolish.
So where do we go with this, Stephen?
Well, what we're going to do, I think, eventually, hardworking lawyers like me and you are going to go out and find a case. We're going to try the case. We're going to make the jury hear the evidence. They're going to make a decision based upon the evidence and the law. They're going to award a verdict in excess with non-economic damages in excess of the caps. And the judge is going to follow the law, which is what we always say to do. And the law is going to say, remit that judgment down to the cap level, whatever that might be. And that's going to present the evidence or present the set of circumstances where we will present that case before a higher tribunal, the Court of Appeals, and ultimately, if necessary, the Tennessee Supreme Court. But I really don't believe it'll have to go that far. I think the Court of Appeals will clearly see that is an issue that exceeds the authority of the legislature and invades the province of the judiciary.
Right. I agree. And for those of you out there listening, you wonder, well, if this is such a serious issue, why aren't we seeing cases like this every day? And the reason why you aren't is because there are good lawyers out there on both sides, plaintiffs and defendants, that are working hard to represent the interests of their clients. And as a result of that, they are mediating to settlement most of these cases, so that if you've got a case that's clear liability and damages or your economic damages are established, and you're dealing with what are non-economic damages, we're privately settling these cases, usually under confidentiality provisions, where people are getting just amounts and resolving the dispute. But the courts aren't seeing it. And because the courts aren't seeing it, because juries aren't hearing those cases because they resolve early, then as a result, we're not having those cases go up. The cases that will go up will be the cases either where liability is at issue, and so there's a horse race basically going on between who really caused the fight, who ran the red light, who caused the accident, who was at fault, or they're going to come in where the damages are just insufficient because of the cap. The defense attorneys aren't willing to pay what's necessary to settle. To an extent, while they may pay a little more than the cap to get the case resolved, they're not going to go what the plaintiff attorney thinks they ought to be paid. And so we get into that situation where those kind of cases, where there's a real argument of what the value of the case is, will be tried. And we'll ultimately get there. We'll finally get a case that's appropriate, and we'll take it up. And not if it's not our firm, it'll be some other firm in the state. And Tennessee trial lawyers will get behind it with their amicus briefs, and the defense bar will get behind the defendant with their amicus briefs, and the issues be addressed both probably before the Court of Appeals and before Tennessee Supreme Court.
Well, so we're at Legal Bytes. This is 800-8949. If you want to give us a call, you can call us and speak with us at our firm, McCoon, Williams, Ashley, and Stanley, 756-6400. We'd be pleased to talk with you about your case. And if you fear you have one of these issues that's coming about, you need to talk about it with us. Be pleased to talk with you about that.
And what put this on my heart is, like I said, I've got a case, a couple of cases right now where the damages are really extraordinary, and talking with the clients to have them understand why they've heard all these stories about verdicts in the past or settlements in the past that are multiple figures, and they don't understand why we can't be getting those kind of numbers today. And while we can seek those numbers, I have to explain to them what the legislature did to the injured people of Tennessee 4 years ago or so, when they put those caps in. And they didn't seem to ever know about it, and I'm not surprised the general public doesn't seem to have a lot of knowledge about it, and they don't understand the purpose of it, or why they're having to suffer when they've got these injuries that they need to have compensated. So,
well, Jim, you want to finish up talking about where we're heading next with the replacement of our fine jurist, Neil Thomas? What's the next step in the process? I know you talked to us a little bit about the commission submitting their three choices to the governor. What does the governor do after that?
Well, the governor will do his own. Actually, Governor Haslam hasn't called me to tell me what he's going to do.
I'm surprised.
My assumption, because it's reasonable, is that the governor will do perhaps his own independent investigation of the three, maybe contact people in the community to find out what they know about the three applicants that are submitted to him by the Vacancy Commission. And he may have them come in for interviews. I don't know of anything that would prevent the governor from doing that. He could have his general counsel get involved in making some inquiries and determinations. And then once he's gone through the vetting process that he deems appropriate, then he will choose and select and appoint the new judge, who will take office, I assume, October 5, which was, I think, Mr. Judge Thomas's last day. And so that's how that'll happen. What's really interesting is you have to understand each one of these candidates are practicing attorneys. They have active caseloads, and they have there are a couple of them that are in very small law offices, so that either they're the only attorney or they've got one partner. And what do they do with those cases? What do their clients do? If they got a case that's pending for trial in November, what happens? And what the rules, the judicial rules provide is, I think they've got 180 days.
That's right, Jim.
To shut down their law office and to basically get rid of their client representations, because they can't continue once they're on the bench. And so what they end up doing is they'll contact other attorneys in town. They'll contact their clients, of course, first, find out if their clients have a particular attorney they'd rather have the file moved to. And if not, then they'll make a suggestion, because they'll, these applicants, whoever's going to be the judge, will have to make contact with some attorneys to see who can take over these files and continue to prosecute them or defend them, as the case may be, so that there's not a gap in representation. And there'll probably be continuous. It's cases that are set for trial shortly after the applicant has to take the bench. Will not be appropriate to push those to trial hard, because you've got to get a new attorney involved. He's got to learn to file, meet clients, figure things out, plus work it into his schedule.
And there's an issue of conflict of interest. I want to make sure there'll be a lot of cases where the judge may have had contact with one or more parties in other lawsuits that may be on the other side of cases, or things where it wouldn't be appropriate for that judge to hear the case, and so they may be reassigned. So we're going to have some of that going on locally also.
Right. I mean, in the past, where an applicant who becomes a judge comes from a large firm, at least for the first few months, up to a year, I think is what has been the standard rule, is those judges don't hear cases coming from the firm that they came from. That those cases will be reassigned to a different division of circuit court. One, because of the relationships and the appearance of impropriety. And two, because, when they were inside those firms, there weren't Chinese walls in place. So
that's no slide on Chinese. That's just a term attorneys use.
That's the term of art, that there were no conflict walls in place to make sure that confidential information on the file was not known by the person who's now a judge that used to be in that firm. And under our rules of ethics, you don't have to have actual knowledge. If there's not a conflict wall in place, the law infers or imputes that knowledge to you, so that anything and everything known by the entire firm is imputed to you if there's not a conflict wall in place. And so as a result of that, there's a genuine ethical reason why a judge who may come from a larger firm should not hear anything with respect to that case for a given period of time. And like I said, I think kind of the course of practice has been a year here locally.
And once again, the law requires attorneys to act ethically and with good conduct in regards to handling these issues. Though we may get bad reputation, Jim, I think that the law really proves otherwise.
Right. And we've got some really good applicants. I'm excited. Judge Thomas has been a wonderful jurist here locally. He's a wonderful asset for this community. I understand that's what he's going to start doing next, is working more in the community. But he's going to be a huge loss to us in Hamilton County in the courthouse. But we've got some good candidates coming in, and I think that we can adequately fill that spot. Not right off the bat, we won't have Judge Thomas's qualities, but I think we'll get there. And that's another edition of Legal Bytes, Chattanooga. I appreciate you turning in and listening to us. Next week, we'll be talking about new and additional topics. Please feel free to turn in, listen to us, and call with any comments. Talk to you next week.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Your marriage is over. You've been abandoned, betrayed. You're angry, shattered, and heartbroken. Don't go it alone. When you are facing divorce, you need an experienced advocate to help protect your rights in future. And you need it from a man with a sympathetic heart, but a hard nose. Attorney Clay Whitaker will fight for you in this most confusing and bitter time.
WBLZ HD4 Ottawa, W224AZ Chattanooga,
WSDT Saudi Daisy Chattanooga.
CBS News, I'm Steve Kathan. Communities along the Texas-Louisiana line are taking on high water from Tropical Storm Harvey, which came ashore early this morning. Port Arthur, Texas is underwater. This man got out of his home by boat.
Everything is floating inside my house. Everything's completely lost. My stuff lost, everything.
CBS's Jim Crisula is in Livingston, Texas.
Most every major road is flooded. Parts of Interstate 10 outside of Beaumont have been inundated by floodwaters. In fact, waves, white